Good morning, everyone. This is Joe Adams here. I'm a U.S. immigration lawyer based in Los Angeles, California. It's 11 a.m. Pacific time on Saturday, December 27th. Happy holidays to everyone if you celebrate Christmas or Hanukkah or Kwanzaa or you don't celebrate anything, but it's the season. I thought we'd interrupt the holidays to assess where we're at in terms of U.S. immigration. Obviously, 2025 has been a year full of challenges in this space, and I always think it's a good idea to get good information out into the public. This has always been an area where there's been a lot of confusion. There's been a lot of rumors, well-meaning and misinformed friends. That's kind of the stock phrase I like to use about those people who maybe they went through a process and maybe they have some ideas about how you should do your immigration, and maybe they're right, maybe they're wrong. 2025 also saw AI explode in this space. I can't tell you the number of clients and prospective clients who have sent me messages that they're clearly using Chat GPT or other AIs to formulate their questions and perhaps give themselves a preliminary idea of what their options are. And again, I always think it's a good idea to have the best information out in front of you so that you can make informed decisions about how you want to proceed with your own immigration to the United States. Despite all the challenges of 2025, the United States economy remains extremely strong. The take-home salaries are amongst the highest in the world of any large country. The U.S. dollar continues to change extremely strongly compared to other currencies around the world. The U.S. remains the heart of innovation in Silicon Valley, in Wall Street, in Hollywood. So these places, which are the capitals of entertainment, finance, technology, medicine, AI, they continue to be the places that attract the best and the brightest. There is historically very low unemployment in these fields, 1-2% typically in these fields seeing unemployment. So there are employers out there, there are foreign nationals out there who are the best of the brightest, who seek to come to the United States to work. I wanted today to be an overview of how the process works, where it falls apart, what the opportunities are. But of course, I'm here to be of service to you. If you have questions while we are discussing any of these topics, feel free to join in. There should be a button on the webinar button at the bottom of the Zoom page. Feel free to ask your questions, and I will do my best to answer all the questions that we have. We have a lot of people who RSVP'd and who are currently in the webinar room. If you have to leave early, no problem. I'll send a recording to everyone who signed up to attend this webinar. So feel free to come and go as you please. I realize it's a Saturday during a holiday, but I thought it was important to get the information out there. So where do we start? U.S. immigration has always been politically charged. It has always been complicated. It's been very rare in the history of the United States that we've sat down as a country and decided what immigration policy is. There are people, including people in my own family. I'm a third generation Italian American. There are people in my own family who will say things like, well, we did it right. You know, these other people, these newcomers want to skirt the system. That's not what we're talking about here. We're talking about the system of lawful immigration to the United States. The system has changed a lot over the last few decades. In the early part of the 20th century, there were racial-based quotas and country-based quotas that limited immigration from many parts of the world. I wrote a book on the subject last year in 2024, called Extraordinary Aliens, summarizing the history of U.S. immigration and especially focused on the extraordinary ability visas and green cards, which we'll talk about this morning. But realize that the ancient system, the pre-1950s system, was relatively informal. People would just, if they were eligible, just turn up at the border. They might have a letter from a friend or from a relative saying, we can support this person or we have a job for this person. And as long as they can pass some health examinations, they would be admitted. In the 1950s, that ancient system was reformed in what we call the Immigration and Naturalization Act, the INA, which for the first time codified all the immigration rules into a single spot, still maintaining racist and racial-based quotas and limitations. And then in the 1960s, President Johnson, taking a cue from President Kennedy, who had been assassinated, President Johnson in 1965 signed into law a major update to the INA, doing away with race-based quotas and country-based quotas and giving us the system that we have more or less nowadays. Then in the early 1990s, President George H.W. Bush, Bush, the father Bush, signed into law a bipartisan bill that created the modern system. It refined the laws that were put into place by President Johnson and expanded some of the employment-based programs and provided for greater border security. That's the system we have now. Part of what motivated me to write the book last year was a reflection on the fact that changing U.S. immigration law doesn't happen very often. The last time it happened was in 1993. I was a little kid, and most of you probably hadn't been born yet. And it hasn't changed fundamentally since that time. That was the product of a bipartisan bill. And so part of what motivated me to write the book was a recognition that the current president, Trump, had a lot of very hostile rhetoric aimed at people who are here undocumented, but also aimed at people who are here lawfully. And it was a reflection of the fact that changing U.S. immigration law does not happen easily. So Trump might come out and say things like, I want to staple a green card to the diplomas of any foreign national who gets a four-year degree. He said that during the political campaign last year in 2024. There was no legislative proposal. There was no change made to U.S. immigration law, but I'll still get a phone call once or twice a week from someone saying, hey, I'm about to graduate with a four-year degree. Where's that green card? How do I get that green card? Similarly, the Trump administration has announced this, what they call the Trump Gold Card. I roll my eyes because it's so not in keeping with my values, but you might like it. If you give the government $5 million, the government will give you a green card. But again, there's no legislation. The president does not have the authority legislatively to create new categories of green cards. I expect this will be challenged in court, and I expect courts will do away with it. Remember, whatever you might think of the U.S. Supreme Court, the Trump administration continually does not do well when its policy proposals and its policy pronouncements are before the courts. So I would expect that sometime in 2026, the so-called Trump Gold Card will, like many things, go away. So we have the system we have now. I don't expect the system will change fundamentally in a way that matters to people on this call. When Trump came into office, he had a lot of priorities that he wanted to enact when it came to immigration. The things that he has control over are things like enforcement priorities. So if someone is in the United States and they are undocumented, are they a priority or not a priority? In past administrations, criminal convicts, people who had been convicted of crimes, people who had terror group affiliation or gang affiliation were the priorities. Now, in this administration, it seems to be anyone who falls into the net is an equal priority. That's something that the administration can control, who is a priority for removal. One thing that Trump does not control is who gets visas, who gets green cards, what are the rules, how do we apply? That's not something that Trump gets to decide on. Those rules have been set by Congress, and Congress won't be changing them anytime in the foreseeable future. So the system we have now is what we've got. As a matter of definition, we have a few different loaded terms. Immigration is full of especially defined terms. There's a lot of jargon that gets thrown around. I really try to avoid the jargon, but sometimes I need to use it anyway. The terms that I've already used are visas and green cards. The way I like to think of those categories is a visa is a temporary authorization that might involve a work permit. It might involve studying. And then green cards are permanent residency in the United States. So those are two different parts of our immigration system. We have visas, which are temporary. They always have an end date. Green cards are permanent residency in the United States. Most lawyers call green card holders LPRs, lawful permanent residents. Actually, that's a term I kind of like. It tells you a lot of information in just 3 short words. Visas, green cards, and then finally, a person who is a permanent resident and has a green card might be eligible after a certain number of years to become a naturalized U.S. citizen. And for many people, becoming a naturalized U.S. citizen is the end of their immigration journey. For other people, becoming a green card holder is the end of their journey. There's nothing that prohibits a person from being a permanent resident for the rest of their life. And that is a status that many people end up on. So let's give an overview of the visas. There are many different categories of visas. And like I said, they all have a different bundle of rights, responsibilities, ways that people can pursue living and working in the United States. They're all categorized by different letters and numbers. So you might hear of what we call the alphabet soup of visas. First-year lawyers are drilled on the alphabet soup of visas because they're all different. They all have their own idiosyncrasies. They all have their own filing procedures and their own end goals. The common visas that I work with as a lawyer who focuses on employment and families, the visas that I focus on are the F1 student visa. Many people come to the United States on F1 or M1 student visas. F1's for academic study, M1 is for vocational study. When a person is in the U.S. on an F1 or M1 visa, the school typically handles the visas. It's a very streamlined process where the school registers the person as a student, and then the person applies for a visa in their home country. Many schools will also have an OPT or a CPT work permit attached to the student visa. These are very helpful. An OPT, optional practical training, occurs after the course of academic study. A CPT, or current practical training, occurs concurrently with the course of academic study. All these programs are different, and you would need to speak to a specific school if you wanted to learn more about their programs. Do they offer an OPT? Do they offer a CPT? There are many programs that have what we call day one CPT. So as soon as you're enrolled in school, you can apply for a CPT work permit and begin working ASAP. Other schools offer an OPT where you finish your course of study, say a bachelor's program or a certificate or a master's program, and then you have an OPT that runs after your course of study, usually proportional to the length of the academic study. During your OPT or CPT period, that's a critical time to build relationships, to talk about future work with your current employer or talk to future employers. For a lot of my clients and prospective clients who are in the world of film or television or the arts or athletics or STEM, they will be building out their profiles towards an eventual H-1B application or O-1 application. So we've talked about student visas, F-1s and M-1s. Those are maintained by the school. You usually don't need an immigration lawyer to get involved in that. It's usually pretty streamlined. I have had to get involved in a few cases, but not many. Then here's the big gap in U.S. immigration for visas. There's a big gap on what happens next. So for many people in STEM, for many people in the arts, for many people in academia or in medicine or in healthcare, they will make a leap from F1 or F1 OPT into the H-1B visa. The H-1B visa has been in the news a lot lately. The H-1B visa is a pretty straightforward program. It's less subjective and more objective than other programs. But unfortunately, there is a severe limitation for H-1Bs that is built into the regulations. The limitation is that for most jobs, there's a limit of 65,000 H-1B visas that can be issued per year, and that's it. Once those 65,000 positions are filled up, you have to wait until the new allotment becomes available. Those new allotments become available April 1 of the year. So as we are finishing up 2025 and moving into 2026, the H-1B season, as we call it, will get started. In years past, there have been 200, 300, 500,000 applicants interested in those 65,000 slots. So how does the government allot those cases? Well, early in my career, the government would ask the applicants. The applicants are always the employer, not the foreign national. In an H-1B, it's always the employer who files the case. These are not self-petitioned. The H-1B employer would complete the application. They'd usually hire an immigration lawyer to prepare the application. They're very detailed. All the I's are dotted, the T's are crossed. They'd send the application into the immigration service, and then the immigration service would lay them all out in these giant mail rooms, these giant conference rooms. I've been to them. They're enormous. They'd lay them all out, and then they would assign by lottery who gets the 65,000 spots. A few years back, there was some innovation saying, hey, why are we asking employers to spend thousands of dollars on applications that don't get selected? Well, so the innovation was, let's assign it by lottery before the application is submitted. So in the month of March, employers are invited to submit applications for the lottery, and there's a nominal fee associated with that. And then if the application is selected in the lottery, then the application is then the employer is invited to submit an application for review. The work authorization doesn't start until November of that year, so there's a gap there that can cause some problems. But that's basically how the H-1B program has worked in the past. There is discussion right now of changing that program to favor higher paid applicants as opposed to lower paid applicants. So with H-1B visas, the rule is that the beneficiary, the foreign national, has to be paid what we call the prevailing wage, not the minimum wage, not the federal minimum wage, but what we call the prevailing wage. The prevailing wage is something that's calculated every year by the U.S. Department of Labor based on geography, level of seniority, and role within an organization. So there's a table that you can look up. What is the prevailing wage for a mid-career computer scientist living in Santa Monica, California? You look that up, and the beneficiary has to be paid at or above the prevailing wage. The administration is talking about changing the lottery to favor higher paid applicants over lower paid applicants. We'll see how this plays out. A rule has not been announced. Notice of proposed rulemaking has not been issued. Changing these rules requires a formal process. And if Trump 1.0 was any indication, they usually bungle this. They usually don't dot their I's and cross their T's to pass rules in a way that survives judicial scrutiny. And you can be assured that anything that the administration does in this area will be challenged. Another issue that's coming up with H-1Bs, and this might be something you saw in the news, the government is suggesting, the administration is suggesting a $100,000 fee to issue H-1B visas to be paid by the employer. So if you are, say, a computer scientist making $120,000 per year, not only must your employer pay your salary, they must file the application, the lawyers charge what they charge, the government filing fees are set by rule, and then does the employer have to pay this additional $100,000 fee? Again, this has been subject to litigation. And right now there are some appeals pending in the Ninth Circuit Court of Appeals, and I expect there will be other challenges filed as well to this suggestion that there be this pretty exorbitant fee paid to the government to process these visas. That's the H-1B visa. We're about to hit H-1B season. There is an L-1 intra-company transfer visa. This is how we move executives and managers internationally. I work, for instance, with a finance company, a hedge fund who has a branch office in New York City. They have a head office in Paris, and they have a branch office in London. They rotate their employees through their offices so that their employees can get a flavor of how the work is conducted and the cultures of the different offices to harmonize their office culture. So that finance company based in Paris, London subsidiary, New York subsidiary, we showed that the foreign national, the beneficiary, has at least 12 of 36 months of work history with the foreign parent. We show that there is a job in the United States. In the past, I'm going back 10, 15 years, there was a high instance of fraud documented in these cases. So the government has always taken a very close look at these L1 intracompany transfer visa cases, and it's critical to show that the companies are bona fide, that they have ongoing operations. And if it's a new office scenario where, say, the Paris company didn't have a U.S. subsidiary, if they're opening a new U.S. subsidiary, is it bona fide? Do they have a plan to hire people? Do they have a marketing plan? Do they have office space? Do they have an organizational chart? And again, the government looks at those historically with a lot of scrutiny, and even more so nowadays. The other category of visa in this alphabet soup that I focus on a lot are the O1 visas. In fact, the book I wrote last year, Extraordinary Aliens, takes its title from the formal designation of the O1 visa. O1 visas are for so-called persons of extraordinary ability or persons of extraordinary achievement. With an O1 visa, there is no requirement that the employer pay the fee. The foreign national can pay the fee. The foreign national is centered in an O1 case. So unlike an L1 case, which is about the companies and their relationship and the bona fide nature of their work, an O1 visa is about showing that the foreign national has a very high level of ability in their field, as demonstrated by their past achievements. So their credits, press, awards, letters of recommendation from experts in the field, evidence of good salary in comparison to others. In addition, an L1 visa requires that we show an itinerary or a plan of upcoming US-based events, work, engagements over a period of time. This is the visa that I typically use for artists, entertainers, people in film and television, high achievers in athletics, high achievers in STEM. Because the H-1B visa program is so compromised, in my view, because there's that 65,000 cap, and who knows what will happen with this $100,000 fee, who knows what will happen with this lottery when it comes to scaling the preferences to the higher earners. We have increasingly relied on the O1 visa, and that was the status quo pre-Trump. When I first started working in this space 15, 16 years ago, I've been a lawyer for 20 years, focused on arts and entertainment, STEM, entrepreneur, immigration for the last 15 or 16 years. The H-1B program was already a problem due to the high level of interest and the relative chances of getting one of those coveted 65,000 spots. The O1 visa has no limit. There's no limit to the number of O1 visas that can be issued per year. And as soon as the visa is issued, the work can commence immediately. So there are a lot of benefits to the O1 visa that really outshine the H-1B program. And then as compared to, say, the L1 program, where you might not have a 12-month work history working for the foreign national company over the last 36 months. So again, for those reasons, the O1 visa is very appealing. But the trade-off is that the O is a high subjective bar. No immigration lawyer can tell you with 100% certainty whether or not your credits will or will not pass muster. And I think it's very important for a person considering an extraordinary ability case, either an O1 visa or an EB1 green card, which we'll talk about in a moment. It's very important that the prospective client understand what the rules are, what the typical forms of evidence are that we typically provide, and so that the foreign national can make an informed decision about whether or not they want to pursue that status based on their goals, their budget, their appetite for risk, their timing goals. Those are the factors that the foreign national should be considering. It's their case, not the lawyer's case, at the end of the day. So that's what we're considering when we look at the alphabet soup of visas. There are other visas that we talk about as well. There's an E2 visa, which is a creature of treaty. So if your country and the U.S. has an investor treaty, some countries do and some countries don't. The big ones that don't have investor treaties, there's no U.S.-Russia investor treaty, no U.S.-China investor treaty, and no U.S.-India investor treaty. So if you're from India, China, or Russia, those are the big ones, then there is no E2 investor visa to be had. If you are from a treaty country, the way the E2 investor visa works is we show a 5-year business plan, a 5-year financial model, and we show that you are going to make a substantial investment in the new or existing U.S. company. Next obvious question, what is a substantial investment? The government doesn't tell us. They don't give us a number. Most immigration lawyers will use a floor of 30 to 50,000. It's a sliding scale. So if your business project is to open a corner cafe, that minimum investment, that substantial investment is going to be a lot different than if you're opening a car factory or a microchip factory, obviously. So it's a sliding scale, but you have to make a substantial investment, and it is a real investment. It's not hypothetical. It's a real investment where money is at risk. There's a very robust market for E2 investors. I get solicitations every week from brokers who broker in potential investment-based immigration opportunities. I guess before my time, 30, 40 years ago, it was kind of a Wild West and people didn't really care about a return on investment. But in the last 10, 15 years, it's become a very competitive market where not only do people want a good return on their investment, of course, they also want their immigration status. So those are the kinds of factors that people are usually thinking of when we think E2 investor visa. Those are the main kinds of visas that we look at for people looking to work in the United States. For families, there are what we call immigrant visas. So if you're engaged to a U.S. citizen or you're married to a U.S. citizen or green card holder, we can apply for a K1 or K3 fiance visa or spouse visa, which allows the person to enter the United States and then apply for adjustment of status, adjusting them into their green card. And then there are ways that people can apply for a green card based on marriage directly from a U.S. embassy abroad. That's what's called a CR1 immigrant visa. We've got a question. Let's see. I'll answer this live. You said that work can commence once the visa is issued, but what is the current delay approximately from when the visa application is received to when the visa is issued? I heard there's a large delay. And what is the difference in time from using the premium processing or not? So very good question. And the answer, unfortunately, is it depends. So let's talk about premium processing first. In many employment-based visa categories, like many things in the United States, you can pay money to get a faster decision. So the timing on all these employment-based application processes like this. How long does it take us to prepare the application? Say with an O1 visa, say it takes us 2 months or 3 months to prepare the application. Nothing comes together instantaneously. Say it takes us 2 or 3 months to prepare the application. We file the application with the immigration service here in the United States. They have an option of either standard processing or premium processing. Right now, standard processing is very slow. They have more applications than they have staffers who can keep up with the work at a decent rate, in my view. But if you pay an extra fee, you get a faster decision. Does that change the outcome? Different immigration lawyers will have different perspectives on that. In my view, there is no difference in the outcome. We can get a positive or negative decision regardless of whether or not we're paying for premium processing. But you will hear disagreement amongst that in my community and online. If we use standard processing in an O1 visa case, I would expect the government would review that case within about 6 or 7 months. If we use premium processing, that means that the government is supposed to respond to the case within 15 working days. So don't include weekends, don't include holidays, 15 working days, so about 3 weeks. Then, once the government has conducted its initial review, hopefully the government comes back with an approval. If they don't, they must issue a request for evidence, or RFE. An RFE does not happen in every case, but it must happen. You must get a request for evidence if the government has any questions about the approvability of the case, and the government must tell you what the issues are. And some RFEs are very straightforward, and some of them are more challenging. A more challenging RFE in an O1 case would be, we just don't think the person has risen to the high level that we're looking for. A more straightforward one might be, we're just looking for more information about the person's upcoming work. That's a more straightforward RFE in my view. Then we prepare the answer to the RFE, we respond, and then the government, again, with standard processing, they can take as long as they want. I would expect another few months. With premium processing, a new 15-day clock starts, and then I would expect a final decision. Very important point right here. If the decision is to deny, if the petition is denied, it is without prejudice towards future cases. So even if your petition is denied, the fact of denial does not mean anything for any future case, including a case in that category. So if your O1 visa case is denied, one strategy could be simply to try again. Take the existing file, add the RFE response materials, add the new materials that have come in since the time of the original filing, and perhaps a different officer looking at the same evidence can come up with a positive outcome. If the petition's approved, then the case is transferred from USCIS, which is a component of the Department of Homeland Security. It now transfers over to the US State Department, and the person, the foreign national, attends a short interview at a US embassy or consulate in their home country. So the difference between petition approval and visa issuance, visa placed in passport, that's usually about a week or two. Different consulates run at different paces. Some of the consulates that are more backed up are like the ones in New Delhi. Some of the consulates that are smaller are swifter. Each consulate posts its own processing times online. So I hope that answered your question. And if it didn't, just send me a follow-up. Another question. What is the success rate and recent approval times, premium processing or not, from transferring status from an O1B to a green card? Is there a different burden of evidence required? Okay, complicated question. So let's go through it step by step. What is the success rate? Well, I don't really keep track of the national statistics. I'll hear them. I don't really seek out that data. It doesn't really matter to me. It doesn't matter what the national approval rate is. I'll tell you this from my own experience. This law firm has had a consistently high approval rate in the mid-90s this year in 2025 and last year in 2024 under President Biden, and going back for the last 15 years. There was never a time in Trump 1.0 or now in 2025, Trump 2.0, where we said, let's hold a case and wait for a better administration. We file the case, we test the evidence, and then we respond appropriately if the government pushes back. And there were a number of cases in 2024 under President Biden where the government pushed back and said, we just don't think the person qualifies. And we pushed back and we won most of them. That held true this year in 2025. We didn't win every case, but we won the vast majority of them. And that I think that goes down to careful preparation, planning, and really trying to build the case as thoroughly as possible. So success rate, recent approval times. Like I said in my prior answer, the processing times can vary case by case and category by category. I don't keep the published statistics in my head. You can look them up on the USCIS.gov website, but the reality is that just gives you an approximation. If the government in a standard processing case goes past its published processing times, there's no automatic consequence. All that allows you to do is format what's called a service request and formally request an update on the case, but it doesn't compel the government to take any action. What happens in real life is many times clients will file a standard processing case because premium processing is more expensive. It's an extra $2,800. And then if it's taking too long, they will upgrade the case post-filing from standard processing to premium processing. I had a number of cases approved in standard processing this year that we had filed in 2024, which causes frustration because sometimes they ding you on the validity dates if the officer is not being careful. Then the other question was transferring status from O1B to green card. Now, nothing happens automatically. So there are some countries in the world where having prior visas lend themselves or lead to a green card approval. The US is not one of them. So having, say, a prior O1B case approved does not grease the skids for a green card. It's always affirmative. We always have the burden of proof. Nothing happens automatically. So what's typical is that someone on an O1 visa, an extraordinary ability visa, say an O1B is for artists and entertainers, the other flavor is O1A is for people in STEM and athletes and entrepreneurs. Say you're an O1B, say you are a cinematographer, and now you want to expand your career, you want permanent residency in the US, we would probably review the EB1 category green card together. So, which is a nice segue into what I wanted to talk about anyway, which is green cards. So like I said earlier, green card is a slang term. It's a term of art. It refers to the physical color of the old card stock. I guess back in the 1930s, 1940s, green ink was hard to manufacture, so it was hard to forge. So they would use green ink. That might be why our dollars are green. Now it's a credit card sized piece of plastic with a lot of security features. It has a magnetic strip that has a digital image of yourself, and it has a digital copy of your fingerprints. They still use the green ink for historical reasons. But a green card holder is a person who is a lawful permanent resident. Those things are the same. So a person who has a green card is an LPR, is a lawful, as opposed to unlawful, permanent, meaning you are a resident of the United States until you die, until you naturalize and become a US citizen, or you commit a very serious crime and get deported. And resident, meaning that you're making the US your home on a permanent basis. You're free to come and go. No one will prevent you from leaving. But the idea with a permanent resident is that you're spending the majority of your time in the United States, that you are maintaining your residence, that you're paying taxes, and people can get into trouble if they are failing to maintain their immigrant intent. That's one way you can lose your green card if you move away with no plan on coming back. And pick up your belongings and have no ties to the U.S. anymore. You would be readmitted on a green card, but the Customs and Border Protection officer might issue you an NTA, a notice to appear before an immigration judge, to prove that you continue to maintain your immigrant intent. Fortunately, that doesn't come up a lot with adults. Where this does tend to come up is with people who got green cards when they were children. They moved away, say, to study, or they met someone and built a family in another country, and then they say, "Oh, well, I haven't been to the United States in many, many years, but I have a green card." The answer is probably they have abandoned their immigrant intent and probably would need to start over. And then, so what's the processing time? Say you're going for an EB1 green card. That's the quickest employment-based method for a person on an O1 visa or another non-immigrant visa to get a green card. I I think of it as about in or out of a year. There are two different steps that we must go through to become a permanent resident. First, you need a classification. You need to be classified uh, under one of our green card programs, and then you need to actually file the green card application. So, step one, how do we get your classification? There are five employment-based classifications, employment-based like EB, EB1, EB2, EB3, 4, 5. EB1 is what most O1 holders will review at some point in their lives. O1s are for persons of extraordinary ability. EB1s are for persons of extraordinary ability. The standards are very similar. It's a high subjective bar. I don't think that anyone could tell you precisely what the difference is. When I was writing my book last year, I interviewed the former member of Congress, now semi-retired lobbyist, who wrote these rules. He was a member of Congress who made this deal happen. And the impression that I got in speaking with him was that they were writing these rules kind of by the seat of their pants. There was this very narrow window where they were writing these rules. They were trying to improve the system, but they knew that there were certain legislative lines in the calendar, and if they didn't hit these certain marks, they were going to lose their window. And so the rules were written in a way that were good, not great. There's ambiguity in the rules. There's duplication in the rules. There are not a lot of cases that get filed in court. You know, sometimes when there are ambiguities in legislation, those get challenged in court, and courts come down with rulings that decide what the intent of the legislature was or what the meaning of the laws are. These cases don't get litigated that much in court. And in fact, there's a really interesting case that I discovered in my research, a case from 2007. It was an EB1 case here in the Central District of California, so in Los Angeles. And the judge, who very well-respected judge, really struggled with how to apply the rules in that case. In that particular case, it was involving a Brazilian jiu-jitsu competitor who had won a collegiate gold medal. So the case is called Braga versus Poulos. Braga goes by the name the Crusher, so I call it the Crusher case. So he's the big bad accomplished Brazilian jiu-jitsu competitor calling himself the Crusher, and he had won a gold medal at the collegiate level. The government denied his green card, and then on appeal, the judge says, I don't know because Congress hasn't told me. Do I compare him to everyone in the world who does Brazilian jiu-jitsu? Do I compare him to other U.S. collegiate athletes? Do I go back to his home country of Brazil and talk and compare him to Brazilian jiu-jitsu competitors? And then what about the Olympians? And what about the professionals? The judge really struggled with that, and that is a reflection of the ambiguity in the rules. There's a link to the judge's opinion on my book's website, and I will send a link to that to everyone who registered. I'll send a link to that website after we hang up, so you can look at that opinion yourself, because it really is an interesting discussion about how the judge really struggled with these issues, and how do we compare apples to apples, you know, between different cultures and different countries, and this is something that modern contemporary immigration officers will struggle with. One of the criteria for O1 and for EB1 reads evidence of high salary or other significantly high remuneration in relation to others in the field. That word high is not defined in the regulation. So when you look at the dictionary says above average, in the top 50%. There are some immigration officers who will make it up as they go, which they're not supposed to do, and they'll say, well, they need to be in the top 10%. That's not what the rule says. So, in fact, I have a case going right now in federal court where this is one of the issues, where I think that the Immigration Service, in denying a green card unfairly and overly restrictive, with too much restriction, applied the salary rule using a made-up definition of high. So that's something that the judge will have to decide. So we're talking about green cards. We're talking about EB-1 green cards. There are five employment-based categories of green cards. EB-1s are self-petitioned. There's no job offer required. There's no minimum amount of salary. Unlike, say, the H-1B visa case or the EB-2 or the EB-3 green card case where there's a prevailing wage required, there is no prevailing wage with an EB-1. There is no job offer required with an EB-1, and you are your own sponsor for EB-1. So those are great benefits to that program. There's no labor certification, which means that we can just file Part 1 right away. And then if Part 1 is approved, where we get the classification that you are an EB-1 worker, then we file the actual green card application. If you're out of the US, that goes through the embassy. That's what's called consular processing. If you're in the US and in status, at your option, you can file for adjustment of status. And like I said, beginning to end, starting the process to green card in hand, give or take a year for EB-1. For EB-2s and 3s, we're looking at 3, 4, 5 years sometimes. For family-based immigration, there again are a list of priorities. We request a classification based on your family relationship. The highest priority family relationships are what we call immediate family members, which are parents, children, and spouses. Spouse of a U.S. citizen, parent of a U.S. citizen, it's as quick as it can be. For other family relations, we look at what's called the visa bulletin. We look at a chart. The lowest priority are brothers and sisters of U.S. citizens, where the wait times can be many, many decades. Sometimes people will come to me and say, well, I have a U.S. citizen cousin or a U.S. citizen aunt or uncle. Those aren't the relationships that the government cares about. It's spouses, parents, children, and brothers and sisters at a very low priority level. Green card holders can petition for their spouses. They can petition for their children, again, at a lower priority level. If you have any questions about family-based immigration, please feel free to jump in. I assume that most people are interested in the employment-based side of things, but I'm always happy to talk about family-based as well. Then, if a person is a permanent resident, they have their green card, they will typically wait 5 years. If it's family-based, married to a U.S. citizen, 3 years, and then the person is eligible to become a naturalized U.S. citizen. The person needs to have maintained continuous residency in the United States for 30 months, and then they can apply to become a naturalized U.S. citizen. A relatively straightforward application process that culminates in an in-person interview. An English language fluency test is given verbally. They just ask you the questions in English, and then they administer a verbally administered civics test where they ask you basic questions about U.S. government and history. You can study those questions in advance. They give you all the questions and answers in advance. The questions are pretty straightforward. What are some of the rights enshrined in the Bill of Rights? Freedom of speech, freedom of religion, freedom to petition the government. What is the capital of your state? California at Sacramento. Name the 3 branches of government: legislative, executive, judicial. If you don't know that, that's fine. You can study it, and it's straightforward. And sometimes the officers will even help you out a little bit if they feel like you're struggling sometimes. So that's an overview of the U.S. immigration process. It is imperfect for sure. It is flawed for sure. It does not always have a good, obvious, easy answer for everyone in every scenario. But using these tools, the O1 visas, the H1Bs, the L1s, using the tools of the employment-based and family-based system, we get there. And like I said, there's a lot of bad information out there, and a lot of that bad information comes from this administration. Obviously, I'm not a huge fan. I don't think there are many immigration lawyers out there who got into this line of work and who are fans of this administration. That being said, and I hinted at this a moment ago, when the government gets it wrong, when they apply the rules incorrectly, when they overlook your evidence, when they mischaracterize things, one thing that we can always do is sue the government. And I like suing the government. I have 2 cases going right now. I usually have a few cases going at any time. Sometimes I inherit these cases from other lawyers. Sometimes they are cases where I represented the person in the underlying proceeding. And what I like about going to federal court in an appeal is the federal court, the judge has, a broad discretion. They're appointed for life. They are not beholden to political interest. I've had Trump appointed judges, Biden, Obama appointed judges. Right now, I think I have a Clinton appointed judge who is on senior status in one of my cases in Texas. So those judges, they have lifetime appointments. They really do take a lot of time and review the arguments very carefully. And then when we sue the government, we are up against the U.S. Attorney's Office. So the government is always represented by the U.S. Attorney's Office. There's a U.S. Attorney's Office in every federal district. These are good lawyers, typically, very good lawyers who work in government service. They do not want to defend a bad decision in front of a judge that they might have 10, 20 cases going at any particular time. So I have had instances, more frequently than you probably would imagine, where we file our lawsuit. When we file our lawsuit, the government gets 60 days maximum to respond. We can extend that one time by agreement for 15 days, so 75 days max. And then the government has to take a position on a case. And I've had many instances where we file our lawsuit, the government, without telling us, they don't make a big fanfare of it, they reopen the case and approve. So I have a case going that's in that phase right now. So we're interested to see what position the government's going to take in our case, because I think the decision is not a decision that the government will want to defend. I think it's poorly written. So that's my overview of the U.S. immigration process. We covered a lot of information in this hour. I realized that I might have gone pretty fast. I wanted to get to a lot of it. If you have any other questions, please feel free to reach out. I'm always happy to respond over email or set up a time to chat via Zoom. And like I said, I'll send an overview of everything we talked about and a copy of this recording after we hang up. Have a great morning, and I'll talk to you hopefully soon. Have a great new year. Happy 2026.